Well, we'll go ahead and get started to be mindful of everybody's time. So today we've got our webinar on the Family's First Coronavirus Response Act and your obligations as an employee. So we have three presenters from Dickinson, Mackaman, Tyler, and Hagen who are going to be speaking with us today about all the changes going on with that. First up, though, I would like to invite our presenting sponsor for the Business Illumination Series to say a few words, which is going to be Trent Murphy. And I will let him say a few words as presenting sponsor.
First of all, thank you everybody for coming in and looking at this webinar. It's unusual for most of us. Usually we're face-to-face and talking. Just a little bit about CJM Financial. We're a family-owned business since 1993. So for the last 27 years, we've worked in the transportation factoring side of transportation, handing or helping small businesses cash flow their business. In this time, obviously, transportation is a very hot topic, and funding those truckers and making sure that they continue to run and be operational is something that we've prided ourselves on for 27 years. And then during this time, because we are a family-owned business, continental United States, a lot of Iowa businesses that we buy the receivables for, we've been able to spread out our staff, like everybody says. We've been able to actually do a lot of telecommuting, work from home, that we had normally would have reserved for other instances, but this is a good dry run. So on behalf of CJM Financial and all of us out there, we wish you to be safe. We kind of embrace this new way to interact, and thank you to our panelists for giving us some good advice today.
All right, thanks, Trent, for saying a few words and being our presenting sponsor for today and for the upcoming webinars that we're scheduling for the next couple weeks as well. So I am going to be speaking on behalf of Craig Toole today. They are our speaker sponsor for the Business Illumination Series for this month. And so I would just like to introduce our speakers. So today we've got Cody Edwards. So Cody leads Dickinson Law's state and local tax practice and focuses on sales, use, and property tax controversy and litigation, multi-state taxation, and general sales and use tax counseling. Mr. Edwards takes a creative approach to the practice of law, which includes utilizing the tools provided by the Iowa Administrative Procedures Act to help solve his clients' state tax issues. Next up, we've got Bryan O'Neill. Bryan is a member of the firm's Employment and Labor Law Group. He handles all types of cases, including discrimination, retaliation, FMLA, wage and hour, and wrongful termination litigation. Additionally, Bryan counsels clients on compliance with state and federal laws and ways to manage and avoid risks. And finally, we've got Melissa Schilling. Melissa represents public and private sector employees in labor and employment matters. In that role, she has successfully represented clients in state and federal cases involving a broad range of labor and employment laws. In addition to her litigation experience, Melissa has experience counseling employers on a wide range of labor and employment issues, including cyber security issues, discrimination, harassment, FMLA, and medical issues in the workplace, technology issues, and discipline matters. At that, I will turn it over to our speakers, and I think Melissa is kicking it off, so I will stop sharing my screen and let her share.
Good morning, everyone. Can everyone see my screen? Can you guys see my screen? Okay. I'll start this from the beginning. Anyway, as you all know, things are changing day to day, and as we're doing this presentation, things could literally be changing as we go through it. So updates will be provided through our law firm's website. We're constantly blogging about these issues. Just to give you an example, yesterday I took a webinar and the Department of Labor had issued guidance within a few hours after that, which changed certain things that were discussed in the webinar. So if that happens, we will be issuing updates through our website. The other thing that came out while most of us were sleeping, at least I was sleeping, is the Congress passed the stimulus bill yesterday or late last night, and that provides, from what I've read, unemployment for, which is the equivalent of 4 months of a person's regular rate of pay if they're laid off or terminated as a result of the COVID-19. It also includes payments to small businesses to help them keep making payroll during this time. Since it was just passed, I have not had a chance to review that and really analyze it, but to the extent it's going to impact small employers, we may be looking into doing something similar, another webinar, to go over how that'll impact your business. But today my focus is going to be on the Families First Coronavirus Response Act, which was passed and signed by President Trump last week. We're going to be discussing a variety of issues, but mainly there's two components to the law, and that is emergency paid sick leave as well as emergency paid FMLA leave that covers all employers with less than 500 employees. And this slide is just kind of showing a brief summary of what those leaves look like. If you're in a position where you're going to have to be required to give these leaves, you're going to be receiving tax credits. And Cody from our office is going to be discussing what those tax credits look like, because this is going to be a huge impact on small employers to provide this type of leave in the coming weeks. The other thing to note is that this law, as well as the stimulus package that was passed last night, were drafted and signed or passed within days. And so they're complex, and there's a lot of issues that remain unresolved. So as we speak, Congress is still working on and introducing bills that could resolve some of the issues that remain outstanding. We're also hoping that the Department of Labor issues guidance on a constant basis to answer some of the questions that are really going to impact your business and how this is going to apply to you. So paid leave and the new FMLA. So all employers with fewer than 500 employees are going to be covered by this law and potentially required to provide this paid leave to its employees. It also covers public employers, so schools, local governments, state governments, and political subdivisions. A question we frequently have received is, why aren't employers with 500 or more employees covered by this law? And what I've been reading is that Congress believes, or is under the impression, that larger companies will have more robust paid leave policies than the smaller companies. It's also my understanding that because there's tax credits, Congress may not be willing to give large companies the same sort of tax credits that the smaller companies will receive when giving this pay. That's simply speculation and based upon news reports, but that's been the constant and consistent theme that I've received. So how do you know if you're reaching that 500 employee threshold and you're going to escape this law? My understanding is that most of you are likely smaller, much smaller than 500, and you won't even need to be worried about whether you're at that threshold or not. But this law essentially requires you to count every single employee that is working for you. And that even includes employees you hire through a temp agency. It would include all employees within the US and US territories. The only persons that would not be included in the 500 employee count are independent contractors. And again, since this slide doesn't really cover most of you, I'm not going to spend a whole lot of time on it, but some employers may look to see whether they can combine entities to reach the 500 employee threshold and escape the leave requirements under this act. And that'll just depend on how they've conducted business in the past, whether they've combined entities in the past under various laws, and whether there's a common management and interrelation between operations. So for instance, if you have an Iowa company, a company based in Iowa with branches throughout the United States, and your HR is centralized as well as other functions are centralized, that's likely going to be one entity for purposes of counting the 500 employees. And again, this applies to both the paid leave provisions and the FMLA provisions. So let's dive into the paid leave provisions. Under the law, employers with fewer than 500 employees must provide 80 hours of paid sick leave to full-time employees who are unable to work or telework due to a COVID-related absence. And we're going to go through those absences here shortly, but essentially it covers six types of absences. Part-time employees will receive a prorated amount of the 2 weeks of leave. So for instance, if they work on average 20 hours every 2 weeks, so 10 hours per week, they would be entitled to leave, paid sick leave, in the amount of 10 hours per week. Now, the Department of Labor has the authority to exempt small businesses with fewer than 50 employees when such business requirements would jeopardize the viability of the business as a going concern. Now, this is likely an exemption that is going to apply to many of you. The problem here is that we don't know what the criteria are for meeting this standard. So the Department of Labor should be issuing criteria in the next few days, hopefully by April 1st, which is when the act becomes effective. And so we can tell you, how do you apply for an exemption, and do you even qualify? Because this really is going to take a toll on employers who are required to pay out this leave to employees when they're under 50 employee threshold. So paid sick leave. There's 6 different types of paid sick leave, and under the law, or for corona-related absences. And I've highlighted highlighted them in different colors for a reason. So the reasons in blue are because those are going to be paid out at 100% of an employee's regular rate of pay if they're taking a leave of absence for any of those reasons in blue. Now the red, those are going to be paid out if the employee is taking leave to care for someone else. And those are paid out at 2/3 of the employee's rate of pay for those 80 hours, or in the case of a part-time employee, for their average number of hours worked over a 2-week period. The interesting thing here is that the law talks about employees caring for an individual. So if you look at reason number 4, now that could be anyone. It doesn't have to be a family member. It could be a roommate. It could be a close friend. It could be a boyfriend or girlfriend. And that would qualify that person for paid sick leave if they are caring for that individual, if that person is self-quarantined or complying with a governmental quarantine requirement. Okay, so a lot of questions we're receiving, and just, I'm going to go back a slide first. So it has to be because the employee is unable to work or telework because of these reasons. And so one of the questions we've been getting a lot is, who decides whether the employee is able to actually telework? So remote work. The law doesn't really address this issue. However, we're taking the position that an employer would have discretion to decide who is able to actually work remotely. So for instance, is the employer able to give the employee the tools that they need in order to work remotely? Is that standard amongst the industry for those types of employees to work remotely? The employer would have that discretion to decide if they are able to work remotely or not. Another big issue that is being asked is, does the law apply to shelter-in-place and ordered business closures? So let's assume, for example, that Governor Reynolds either today or tomorrow issues a shelter-in-place for the entire state of Iowa. Does that law now require small Iowa businesses to pay out the sick leave or pay out the FMLA leave? That answer is we don't know that. However, the spirit of the law makes us think that it would apply to those types of scenarios. What we're telling clients at this point is to wait until April 1st to really pay out any sort of leave, and two, to wait until we get guidance from the Department of Labor to determine whether it actually does apply in the scenario of a shelter-in-place or an ordered business closure. We're also going to talk later on about what's going on now, and that is places are closing or reducing their staff because there's a lack of work and there's a lack of there's a lack of spending out there. So there's not much of a need for all of the employees, and we'll get to that later on in more detail. So another question we're getting is, what the heck does reason number 6, the catch-all provision, mean? And just to go back a slide, the catch-all is an employee who is experiencing any other substantially similar conditions as specified by the Secretary of Health and Human Services in consultation with the Secretaries of Labor and Treasury. We really don't know what that means. We assume it means that if COVID-19 were to mutate in any way, or if there's going to be another big issue with the seasonal flu, then maybe they would resurrect this type of law or have it apply for the rest of the year in those types of situations. Again, we're looking for more guidance from the Department on Labor as to what this catch-all provision means. So from your standpoint, the real things you need to be concerned about are reasons 1 through 5. So how is this documented? The law does not talk about what type of documentation employers can ask for from employees to actually justify them being gone. For medical related absences, we're taking the position that a doctor's note would be acceptable. Now, it may be more difficult for employees to get doctor's notes in light of the fact that the healthcare system is starting to become overwhelmed, as well as the fact that employees are not being tested right away if they're only experiencing mild symptoms. So you should allow some leeway for those types of employees who may not be able to get a doctor's note right away, and give them a reasonable time to provide a doctor's note. With respect to a non-medical related absence, for example, caring for a child because the school has been closed or a daycare has been closed, you've got to ask yourself a question as, well, we know all the schools in the country are closed, so do I really need something from the school to show that the employee is caring for the child because school is closed? You probably don't. But if it's related to a daycare being closed, one thing you could use is an email that the employee received from the daycare, or a text message, or a website announcement. That's something that the employee could provide as proof that they are in need of the paid sick leave because they need to care for a child who daycare has closed. The other thing that's not addressed is, does a 15-year-old or 16-year-old or 17-year-old really need a parent to be at home to care for the child that's not in school or in daycare? In those situations, I would ask the employee, well, what do you do during the summertime when the child does not have parent supervision? The other thing is, some kids may have special needs that would actually require the employee to stay home. So those are all issues that may arise for you. Paid sick leave for full-time employees is paid out for reasons 1 through 3. So essentially when they are caring for themselves or they themselves are quarantined, that's paid out at their regular rate of pay. Their regular rate of pay needs to include overtime. It is capped at $511 a day or $5,110 in total. For reasons 4 through 6, which basically concern the individual taking care of another person, you pay them out at 2/3 of their rate of pay for those 80 hours. And again, that is capped and that's shown. If you have full-time employees who are not consistently working, let's say 40 hours a week, or their hours varied, you would want to see how many hours over the course of the last 6 months they've been working and take that on an average. Same with how to determine their regular rate of pay. Part-timers, a part-time employee is entitled to leave for his or her average number of work hours in a 2-week period. And again, they would get that at their regular rate of pay, which it's doubtful they would be working overtime, but if they did, that would be included. And you need to look back at 6 months to see what their average number of hours that they're working is. So some special rules. If you currently have a paid sick leave policy or a PTO policy, this law requires you to pay these extra 80 hours in addition to that. So you cannot just rely upon your current policy, no matter how generous it was. Even if you tried to, prior to this law becoming effective, try to give employees paid leave for COVID-related absences, you cannot rely on that to supplant these leave requirements. They are all going to be entitled to it no matter what your paid leave policy is. The other thing is they're eligible for it on day 1 of employment. So if you just hired an employee, they are going to be eligible to receive this sick leave pay. Doesn't matter how many hours they've worked or how long they've worked. And it applies to all types of workers. So full-time, part-time, temp workers, seasonal workers, workers you've hired through temp agencies. It cannot be carried over to 2021, so the law does expire or sunset on December 31st, 2020. So it's not going to be in effect next year as of right now. We're going to get into this in a little bit, but employers of healthcare workers can exclude healthcare workers, and we're going to have a more detailed slide on that in a little bit. So if you are in the healthcare industry, you may be able to exclude some of your employees from that. So with that, I'm going to turn it over to Bryan to start talking about the FMLA.
Thanks, Melissa. Because the EFMLA, the Emergency Family Medical Leave Act, is based around the Family Medical Leave Act, I wanted to provide a little background, particularly for employers with less than 50 employees that normally would not be covered by the FMLA. The EFMLA, it didn't expressly change the FMLA, except for the portions that we're going to discuss here today. So if you're wondering about whether any other provisions normally impacted or would be impacted by the FMLA, they are not. The FMLA is going to continue on as it was. And Melissa and Cody and I are all sharing a slideshow, so I'm just going to prompt Melissa to forward for me when I'll need it, and we'll do that now. So real quick, jumping back to FMLA, so eligibility for an employee under the standard FMLA, the employee needed to work for the company for a period of 12 months. They had to work at least 1,250 hours during the 12 months prior to the FMLA leave. And then, of course, the employer had to employ 50 or more employees within a 75-mile radius. So there was fairly strict limitations on who FMLA would apply to. As for qualifying reasons for FMLA, birth of a child, placement in adoption, a serious health conditions, and there are several factors of what can constitute a serious health condition. Care for an employee's spouse, son or daughter, parent who has a serious health condition, and then some qualifying reasons when a spouse, son, or daughter has military leave. Moving on to the next slide, the nature of the leave and what you would be entitled to under the Family Medical Leave Act. It entitles an eligible employee of up to 12 weeks of leave. That leave is unpaid. Employers under the FMLA have the option to run the leave concurrent with any available leave that the employee may have. So for instance, if an employee had 12 weeks of PTO available, the employer could choose under the FMLA, so long as it's in a written policy, to mandate that the employee use the paid leave available before exhausting and going into unpaid status. And then the employer, like I said, has the option of running that accrued paid leave. So that's sort of the background for the FMLA. Let's talk now about what the new EFMLA covers and what it provides different and distinct from the FMLA. So recently signed into law, it has not gone into effect yet, and it is not retroactive from everything that we see. So you do not need to be providing this right now. You probably need to wait. I think Melissa covered this a little bit in the paid sick leave, emergency paid sick leave. In terms of getting the tax credit for this, you don't want to start too early, or you may not be eligible for that tax credit. So probably should be waiting until April 1st. And just like with the employee or emergency paid sick leave, this is going to apply from April 1 to the end of the year. So we got a 9-month window, very short window. It's intended to expire unless we have additional congressional action, which, hopefully we all get through this fairly quickly and safely. But if this were to extend longer, there's a chance that this could be extended as well. Moving on, let's talk a little bit about EFMLA eligibility. So just like with the paid sick leave, it's going to apply to employers with 499 employees or less, and public agencies as well. So schools, local governments, local government subdivisions. And unlike the emergency paid sick leave, which is effective immediately, this is going to apply for employees that have been employed for 30 calendar days. That does not mean they need to have worked 30 days for the employer. They just have to have been employed for 30 calendar days. So a little distinction from the employee paid sick leave. Moving on to qualifying reasons for the leave. The employee, if the employee is unable to work or telecommute because they must care for a child due to the child's school being closed, due to public health emergency, or due to a child care provider being unavailable due to a public health emergency. So unlike the paid sick leave, where there's the 6 categories, this really only has essentially the one, which is you need to care for a child because either the school or the daycare provider is closed. So unlike traditional FMLA, the EFMLA is really an extremely narrow window. And it's only going to apply to those care issues related to closure of school or daycare. Moving on to the nature of the leave, EFMLA provides, just like with FMLA, up to 12 weeks of leave. The first 2 weeks are unpaid, sort of, and I'll get into that in just a second. And employees, this is a distinction from the FMLA, the employees themselves, rather than the employer, can choose to use paid leave for the first 2 weeks. The employees, however, cannot require that their employees do this. So a little distinction there. It's more employee friendly, and it's up to the employee how they want to use that leave. So the remaining 10 weeks of the leave, so the first 2 weeks under the EFMLA are not paid. The remaining 10 weeks are paid at 2/3 of the employee's regular rate of pay, multiplied by the number of hours the employee would have been scheduled to work. However, that pay cannot exceed $200 a day or $10,000 over the aggregate 10 weeks. So I want to get into that because it's a little misleading to say that EFMLA only covers 10 weeks. Well, that's technically true. there's a bit of interplay with the emergency paid sick leave that Melissa just talked about as well. Under reason number 5, so Melissa gave you 6 different reasons of when employee paid sick leave would be available. Under reason number 5, which is for an employee that is caring for a son or daughter whose school or place of care closed, or the child care provider is unavailable due to COVID-19 precautions. In that scenario, the employee can get 2/3 wages for emergency paid sick leave. So because this is still going to be available, employees that are using EFMLA, they would also be eligible for the emergency paid sick leave. And of course, the emergency paid sick leave is going to be the 80 hours, the first 2 weeks. This could bridge the gap until the EFMLA kicks in. So in reality, an employee could get up to 12 weeks paid, or at 2/3 of their regular rate of pay. Employees could choose to use their available paid leave to cover any shortfalls. If they have some available, they could use the leave that they have banked to cover the extra 1/3 that is not covered by the EFMLA. So when you combine the emergency paid sick leave with the emergency FMLA, still the pay is not going to exceed $200 per day. And then the aggregate for the total of the 12 weeks, you're going to have, the total is not going to be greater than $12,000. So I want to talk about regular rate. And this is something I think is virtually the same with the emergency paid sick leave. And Melissa covered this a bit, so I won't go into great detail. But the regular rate is the average of your regular rate over a period of up to 6 months prior to the date you take that leave. So if you've worked for the company for a number of years, for the employer, you just look back at the last 6 months to calculate what that average would be. If the employee hasn't worked for the employee for 6 months, then the regular rate is the average of your pay for each week worked for the employer. And, excuse me, these may include overtime, they can include tips, they can include commissions, with the understanding that they're not to exceed still the $200 per day, and $10,000 total for the EFMLA, and then $12,000 total when you combine emergency paid sick leave and the EFMLA. So moving on, employees are entitled to, just like with the FMLA, they're entitled to job restoration to their previous job or an equivalent job at the conclusion of their leave. The exception contained in EFMLA would apply to employers with less than 25 employees if the positions no longer exist due to operational changes caused by the public health emergency. So essentially, if you're laying off permanently a number of your workforce, that would be an exception to this. However, if the position no longer exists, those employers would need to make reasonable efforts for up to 1 year to restore the employee to an equivalent position. So essentially what this is looking at is if the employer has to shutter or greatly reduce their workforce because of issues with COVID-19, once again, we all hope this ends as soon as possible and everyone comes through healthy and safe. Once that does happen, if the employer is able to expand the business, then these employees would need to be considered to have their job restored. Moving on, DOL has the authority to exempt employers with less than 50 employees from the EFMLA regulations or the requirements, and it would do so where it would jeopardize the viability of the business as a going concern. Just yesterday, the DOL issued some guidance, and here's what they said, and take this for what it's worth. It said, to elect the small business exception, you should document why your business with fewer than 50 employees meets the criteria set forth by the department, which will be addressed in more detail in forthcoming regulations. So I'm sure that's clear as mud for everyone. I know it was clear as mud for me. I think the important thing is if you're under financial strain because of this, you need to document why that would be and be prepared to justify that to the Department of Labor. Like Melissa said, this law just passed. We're still getting guidance from the DOL, and we anticipate getting more in the coming days. So this is something that we're going to update as soon as we get it in blog posts on our website. But right now, I think you need to make good faith efforts to comply with the law. And if you cannot comply with the law, if you're one of those employers that's under 49 employees or under, you need to be prepared to justify why you can't. So moving on, this would be for, excuse me, I want to make sure I'm on the same slide. This would be for, so Melissa mentioned a moment ago, for healthcare providers or emergency responders, it could be excluded from the EFMLA. And this is going to be a narrow window here. So not everyone in the healthcare field would be exempt from provisions of EFMLA. So certainly doctors would, doctors of both medicine and osteopathy, podiatrists, dentists, psychologists, optometrists, chiropractors, nurse practitioners, physician's assistant, clinical social workers, those would all be exempt. However, just as an example, clerical staff working at a hospital, they likely would not be exempt from provisions of the EFMLA. So you want to look to see and make sure that they're actually on, I guess, what I would call the front lines of the healthcare field. Moving on, this sort of addresses what I just talked about a moment ago. You want to make sure that the person is truly engaged in the healthcare profession. Not to say that those providing support for hospitals and clinics are not, but I think what the law anticipates is the exemption is only going to be applied to those that are actually providing treatment to patients. So you want to do this on a case-by-case basis. And we're going to move on to the next one. I want to talk about layoffs and terminations. So does the law apply to employees that are terminated? Does it apply to those that are on layoff or that have been ripped? What are their rights? So I think what we can safely say is that if an employee is terminated, they're not entitled to, or if they're subject to a reduction in force, they're not entitled to the benefits of the employee paid sick leave or the emergency FMLA. It's a little bit different depending on what your terminology may be for a layoff or for instance, a furlough. If an employee is laid off, technically the definition for a layoff is a temporary cessation of work. The idea is that the employee would still be coming back to work. They may be eligible. Again, we don't have great guidance from the DOL, but they certainly may be eligible. And then for those employees that are furloughed, which is just a leave of absence, it's more likely than not that those employees would still be eligible for some of these benefits. I want to talk about what the defense would look like for some of these actions. So over the next 30 days, or I guess 30 days from the implementation, so for the month of April, DOL has already put out guidance that they will not do any enforcement actions. They're hoping and they want employers to work to do their best to comply with the law. Obviously, it's not going to be perfect from the get-go because employers have not had a lot of time to try and get up to speed on what to do. So DOL has put out the word that they are not going to be enforcing it for the first 30 days. Additionally, for employers that have less than 50 employees, they would not be subject to civil lawsuits for violations of the EFMLA. For those employers that are currently subject to the FMLA, they probably know that employees can bring civil actions for retaliation, for interference, for FMLA discrimination, for violations of the FMLA. that would still apply for the EFMLA, but not for employers that have 49 employees or below. So they may be subject to court fines or court enforcement, but not private civil actions. So moving on, I think I already talked about the difference between furloughs, layoffs, and terminations. PTO versus unemployment, I want to talk about that real quick. There's some guidance on Iowa Workforce Development's websites about when an employee may receive unemployment prior to, and what their guidance is prior to receiving the unemployment. All PTO, sick leave, any leave that's banked must be exhausted before receiving unemployment. So that's something to consider as well. And I am going to, one more issue, moving on to the next slide. Relief, unemployment issues. So for relief for small employers, first quarter unemployment tax payments that were set to be due April 30th are now delayed until July 31st. So there are, like we sort of mentioned, Melissa mentioned, I've mentioned, I know Cody's going to mention as well. This is a very fluid situation, and I know that our state and federal governments and our local governments are trying to do their best to provide relief where they can for employers. So this is something I think that is likely to be updated depending on how long the situation continues. But I'm going to turn it over now to Cody.
Thanks, Brian. I'm going to talk about how the government expects for you guys to pay for these this paid leave in a time when a lot of businesses are hurting. A lot of a lot of the demand for businesses, services, and goods is slowed down. So as Melissa and Brian has told you guys, the government has required employers to provide certain emergency paid leave to their employees. So how do they expect you to pay for this? You're going to pay for this, and they're going to fund this this paid leave through a tax credit. And the tax credit is as a refundable tax credit, meaning that if you don't have enough taxes that are being paid to fully utilize the tax credit, then the government will provide you a refund. And this tax credit is equal to 100% of the wages required to paid under these emergency leave acts that are paid for each calendar quarter. And then, like I said, to the extent that the wages paid where the tax credit exceeds the taxes paid for each calendar quarter, the employer is entitled to a refund. The credit amount, pretty simple to calculate. It's the wages paid under the EFMLA and the EPSL. So long as you know the wages you have paid, you know your credit amount. So as Melissa and Brian have said, this is a fluid situation, and this is developing on a day-by-day or an hour-by-hour basis. That's the same for how these credits are going to be administered. The law, as written, says that the credit is applied against the employer's portion of the Social Security taxes for all employees. So that is 6.25% of the wages. And then if the wages under the EFMLA and EPSL exceed the amount of the employer's Social Security taxes, the excess credit is refundable to the employers. So that looks good until you start thinking about how that works. The way this would work is, let's say, for example, in April, you provide this emergency leave, the emergency paid leave, then the employer is able to take a credit. But the way this works is that the credit would be taken on the quarterly payroll tax return. So if we have, let's say, for example, we have $15,000 in wages paid in April under these emergency leave, we would have to wait 2, 3, 4, 5 months in order to get this credit and this refund. And a lot of small businesses right now are not able to cash flow that $15,000 or $30,000 in wages for 2 or 3 or 4 months to wait for that credit and that refund. So even though this bill was signed into law on March 18th, it took the IRS and the Treasury and the Labor about 2 days to figure out that, you know, this isn't going to work in practice. So what they did, they provided additional guidance on Friday, March 20th. Next slide, please, Melissa. So what this updated guidance says and is intended to do is just allow that employers to immediately retain and access the funds that they would otherwise pay in the payroll taxes. So these payroll taxes are what we call trust fund taxes. And that means that the employer holds these funds in trust for the United States government and has to remit those to the state, to the government. The guidance says, no, you guys can go ahead and use these funds and you don't have to submit them to the government. Another thing this guidance does, it increases the types of taxes that the credit can be applied against. So if you recall, the law as written says that the tax credits must be applied against the 6.25% employer share of Social Security taxes. The guidance indicates that the new taxes the credit can be applied against includes federal income taxes and both the employer and the employee shares of Social Security and Medicare taxes. And this applies to all employee taxes, not just the employees who are being paid under these emergency leave acts. And you know, with that expanded types of taxes, it's less likely that the employers are going to be requesting a refund. But in the event that the tax credit exceeds the amount of taxes that it should be applied against, the IRS has indicated that the employer can submit this form called a streamlined claim form that is not yet public. They can submit that to the IRS once they determine they're due a refund, and the IRS has said that they'll process these claims within 2 weeks of receiving the forms. So if a refund is due, hopefully the IRS will process these in a timely manner, and the employer won't be cash flowing these wages for too long. Like I said, this credit is not that difficult. So the guidance has provided 2 examples of how these credits apply. Next slide, please, Melissa. The examples are as follows. You can see how easy it is here. Employer A paid $5,000 under EPSL and is otherwise required to deposit $8,000 in payroll taxes from all employees. Employer A could use up to $5,000 of the $8,000 of taxes it was going to deposit for the qualified sick leave, and then the employer would be required to only deposit $3,000 on its next regular deposit. So it paid $5,000 out, it owed $8,000 in payroll taxes, it gets the credit of $5,000. The next example is an example of when a refund is due. Employer B paid $10,000 under EPSL and is otherwise required to pay or to deposit $8,000 in payroll taxes. Employer B could use $8,000 of taxes to make the qualified leave payments, and then can file that form that we have yet to see to get a credit or a refund of the remaining $2,000. So relatively straightforward. The key here is tracking the amount of wages you have paid under this on these emergency leave. And the final piece of this would be the tax credit for self-employed individuals. This is really available to self-employed individuals if they have to miss work for any reason, any of those 6 reasons that was covered under the EPSLA or EFMLA. This credit is different than for the employers, where the self-employed takes the credit against their income tax return, and then the credit reduces the estimated income tax payments. The credit amount is subject to the same limits, but is calculated using the daily self-employment income. So the limits are the $511 per day or the $200 per day, depending on the case. But then you calculate your daily income using this average daily self-employment income. I haven't looked into how you calculate that average, but if anybody runs into this situation, I'm happy to help you guys figure that out. That's all I have for the tax credits. Like I said, the key here is to just determine how much wages you're paying out, and that will be the tax credit amount. And you should get a full credit or refund for those wages that are paid out. And that's all I have. And I think that's the end of the presentation. Is that correct, Melissa and Bryan? You guys have anything else to add?
I don't, other than we've got a lot of questions and I'm trying to get through those and answer them. Bryan, I don't see any tax related questions yet, but we've got them in the question and answer section as well as the chat function. So Jessica, do you want me to answer those now, or should we answer them in writing?
Yeah, no, we've got a couple minutes, so we can go ahead and answer them via the chat or via video. So we can, it looks like Matthew's got the next question. He had asked, are all full-time employees eligible for 80 hours, excuse me, of paid sick leave, even if they're not 40 hours per week employees? Example would be 30 hours or 32 hours.
So the way the law is written is confusing. We're taking the position that it would, it's based upon the number of hours they normally work in a work week. So for full-time employees that are only working 30 hours a week, what they're eligible for would be 30 hours a week. Same with individuals working 32 hours a week. Now, if we get guidance that is different than that, we'll again be updating our website with that information.
Okay. Debbie had the next question. She said, if an employee is able to work from home and care for his or her children at the same time, there's no EFMLA that needs to be given, correct?
Bryan,
Correct.
do you want to answer that?
Yeah, that's right. I mean, the law is anticipating that you're not able to work due to having to care for a child. So I think a lot of us are at home with our kids currently in the basement on their iPads, hopefully staying quiet. And just because they're home doesn't mean you can't work. The law is anticipating that you're not eligible to work because of the care issues that you have. So if they're at home and they can telecommute and they're still able to work, then they would not, this would not apply to them.
Okay. Thanks, Bryan. We had somebody submit a question anonymously. They said, you didn't mention RNs, LPNs, and CNAs / patient care techs as exempted healthcare employees. Is that correct?
So I guess my answer to that is I'm not exactly sure. The law specifies those job categories that I mentioned. It's a little less clear on some of these others. My best guess would be that those probably would be that they would be exempt, because again, they're those employees that are actually providing care, as opposed to, you know, other employees that may work for a hospital. So my best guess would be that they likely would apply. The exemption would apply to them.
Thanks, Bryan. Next is another anonymous question. If an employee chooses to take some time unpaid, does that negatively affect any unemployment calculations for them down the road?
I guess it could. It depends on how, unemployment's very complicated, and it looks back at a period that's pretty significant. So if it's just going to be a short-term unpaid leave, it's not going to have a major impact. But if it's going to be a longer-term thing, then it's going to start to impact their unemployment calculations. The other thing to mention, which I don't think we mentioned, was if an employee is taking PTO to cover not being able to work, they're not going to be entitled to unemployment unless they're not making their full amount of pay. So that's another thing to keep in mind.
Okay. The next question I'm going to pull from the chat section. So somebody had submitted, we cannot provide our employees who traveled for spring break and are quarantined at home before April 1st, the 80 hours of paid sick leave, ? They must use their own PTO or be unpaid, ?
Since the law is not in effect, up until April 1st, you should be requiring employees that need to be off work, whether they're quarantined or have coronavirus-related symptoms, you should be requiring them to use PTO or taking an unpaid leave of absence. I know some employers are implementing these required quarantines where they cannot come into work because they've traveled for spring break, and that's absolutely okay to have them use PTO or take it unleaved at this point in time because it's not April 1st.
Okay. Next question from the Q&A is how do you document or defend furlough versus layoff?
I would just look at past practices. I have some clients that are in the construction trade, and seasonally they will do layoffs for their employees over the winter months. Just looking at past practices, I think you can say, well, this is a company that regularly, lays off during the off season for their business. Furlough, I think it would be the same. Have you, not to say that you can't start furloughing employees now, but you need to consider what are the past practices that the employee has done, and using that as a basis to defend why and how you've been doing it and how you've documented it.
Okay. So we'll take one more question from the Q&A, and then I'll have the panelists go ahead and answer the remaining ones that have already come in. And then it looks like we had one more question come in via chat, but we'll answer one more live, and then we'll leave the chat and the Q&A open for a couple minutes while we get some answers responded before we close out the webinar. So Julie Mangles had put in a question, if we did the voluntary shared work program, does it have to be every employee on staff?
Okay, and for those that don't know what a voluntary shared work program is, it's a program through Iowa Workforce Development, which is the governmental agency that works with unemployment. And it's an alternative to laying off your employees. So essentially what you're doing is reducing the amount of hours your employees are going to be working, and the reduction is between 20% to 50% of their overall hours. As part of the paperwork, you have to decide what is considered the work unit. So which employees in your staff or at your company are going to be considered for this program. So it does not have to be every single employee working at the employer. It could be, for instance, all front desk administrators. It could be at a law firm. It could be all legal assistants. So the work unit is the unit that's being looked at to reduce the hours. And even then, not everyone in the work unit may be subject to the voluntarily shared work program if you allow certain employees to work more than others.
All right, well, I'll have our Melissa, Cody, and Bryan answer the last remaining questions via chat for the Q&A and in the chat section. So if you guys don't mind hopping into those and answering those questions to the people who had submitted them. I just want to take one last minute to thank our speakers today. They took time out of their busy days at home and their work schedule to bring us all the latest information on all the questions that have been burning through your businesses and questions on your mind. So thank you for taking the time today, guys. And then I just want to turn it back over to our presenting sponsor, Trent with CGM as our presenting sponsor. And then I also do want to thank our speaker sponsor, Craig Toole. Both of their support today were able to help us bring you today's webinar and our future webinars, which we have our next one on March 27th. And it's on the 𝗤𝘂𝗲𝗀𝗃𝗍 Together movement that we have started with several leaders within the community. And so we'll be going into the small business grant process that we're starting to offer through the 𝗤𝘂𝗃𝗍𝗃 Chamber. So with that, I'll turn it back over to Trent to close us out.
I just want to say thank you very much to our speakers, our panelists that talked. As a small business employer, it's very, very interesting times, and it's good to have the Chamber of Commerce of 𝗤𝘂𝗃𝗍𝗃 and other good people helping us migrate through these kind of questions. Again, just want to say thank you, and I appreciate everything the Chamber's done and the speakers have done.
All right, thanks, Trent. Like I said, we're going to leave open the webinar to answer those questions that have come in, but that is the end of the live webinar for everybody. Hopefully you'll be able to join us on Friday for our next one at noon, and for the upcoming ones in the future weeks. So thanks, and